Good afternoon, ladies and gentlemen. This legislature is back from recess. Before we broke, there was a motion to go into the committee of the whole. If I can have the Sergeant of Arms bring the members. Yes,
Madam Speaker, I also like to request and move that the body invite Ms. Jackie Marati as a courtesy also to be present in this committee of the whole.
Um, I don't know if I have an objection right now, but I thought this focus was to bring in the Attorney General, bring in Reverend Tax, bring in Mr. Cunliffe to talk about the legality of these machines. So I don't know where Ms. Marati would fit into that picture. So if
Um, I, if we heard Ms. Marati's testimony yesterday, she actually, was opining on the legality of the machines, and given the family history, I think I would say that her opinion would matter, given the basis of where that discussion would have occurred.
on the floor. There's a motion on the floor to
in that
consider.
case, Madam
if
Chair,
Ms.
in that
Ms.
case, Madam Chair, I'm gonna move to not start this until we invite as well the vendor, well, at least one vendor who provided testimony. I think we got to take into consideration his
We're going to go
viewpoint.
ahead and take
He's
a
owed millions of
minute
dollars.
recess. Mr. Senator Rodriguez, ladies and gentlemen, we'll go ahead and take a minute recess as I look at the technical aspect of the consideration of the motion. there was a motion on the floor, and before we broke, Dennis Rodriguez, you, that Ms. Jackie Marati be invited in to be a part of the panel discussion.
And I object to that, Madam Chair.
On that motion, there's been an objection. All those in favor to bring Ms. Jackie Marati in to speak signify by raising your hand. Motion fails. Clerk, did you get that?
Madam Chair,
Yes.
since we are focusing on the legal aspect of this one issue, I see that the Governor's Legal Counsel is here. And I think since the Reverend Tax Director is going to be in here, he should be afforded the opportunity of having Attorney Miller with him as well.
Is that a
But is Attorney Miller the attorney for Revenue Tax? Has its own lawyer, and that's the Attorney General's office. No,
But-
he's assigned from the AG's office, but so.
But at the public hearing, if I recall correctly, we've heard the Reverend Tax Director say that he answers to an appointing authority, and he was ordered to issue these licenses, and so we want to have some legal
Senator
basis
Rodriguez,
to
this
it.
is what we'll do. We'll send in the party, and if there's any questions that relates to that, that would need consideration of that, I will entertain that motion at that time. So at this time, I would go ahead and ask that the parties that were invited and accepted to come in at this time.
So you're rolling my motion out of order because I
I'm
asked
gonna
that
rule
the.
it- I'm going to
So if we have a-
table that,
Okay, ma'am.
and
So
until
if we
the
have a.
question is asked,
if-
and based on the.
But be careful what you're doing because if a question is asked in how this legal aspect leads to the social aspect, then you're going to also invite other parties in. So I'm asking that the framework of this discussion be exactly what we agreed to when we resolved in the committee of the whole. And so from the very beginning, I'm asking that Attorney Miller also be extended the courtesy and invited to be part of the panel since she, if I recall, she was involved in this whole issue.
If there's an objection to that, Speaker Ben, then I'll go ahead and entertain it the same way that I've entertained the previous motion. So are there any objections to the motion as presented by Majority Leader Respicio? Is there an objection? There's an objection. The motion is to invite Attorney Miller, who is a part of the Attorney General's office for Revenue Tax. The governor's, then Senator Respicio, restate your motion, please, for the record.
No, she's the legal counsel to the governor, and I think she would also double as providing the governor's position on this issue. So
Ladies and
that
gentlemen, on that
that
motion, there
benefit
was
is twofold.
on that, there was a motion, there was an objection. Let's call for the vote. All those in favor to bring Attorney Miller in, signify by raising your hand, please. Motion carries. Can we please bring in the parties? Good afternoon, ladies and gentlemen. Thank you for coming in this afternoon as you sign in the sign-up sheet. I'm going to go ahead and start from my left. Just for the record, if you can state your name, where you're from.
My name is F. Randall Cunliffe. I'm from the law firm of Cunliffe and Cook.
My name is Sandra Cruz Miller. I'm from the Governor's Legal Office.
My name is John Camacho. I'm the Director, Department of Revenue and Taxation.
Well, my name is Lenny Rapadas. I'm the Attorney General of Guam.
Patrick Mason, Deputy Attorney General from the Attorney General's office.
Okay. I'll entertain Senator Rodriguez at this time. If anyone else wishes to ask any questions of the panel members here, please just raise your hand. I'll note you, write you down, then call you up. Senator Rodriguez, you're recognized.
Thank you very much, Madam Chair. Good afternoon, General, Pat, John, Sandra, and Senator Cunliffe. Good afternoon. Thank you for being here. First of all, before we start, I just want to make something clear because I was told earlier that, and for the record, I know I spoke to you earlier, General, that we did notice your office about the public hearing, and it was broadcast in several other news organizations, and I think in one of those organizations it was broadcast that you would be attending. So I just want to make it clear that we did invite the Attorney General's office, and so that's where we're at. Okay, thank you, sir. Okay, and so I guess we're here today. We've brought the panel in to. There's some question about the funding source of Bill 20, the amended bill, where we're seeking to capture revenue from gaming devices that have been licensed by the Department of Revenue and Taxation earlier this year, which is in beginning of April. And so I believe there's questions about whether these are legal or not, and I've said that they have a duly licensed document from the government of Guam that says that they're able to operate. So that's why we're here. And so I don't know, Madam Chair, if I can reserve my time. I want to be able to come back and speak if there's any other questions out there.
If I can briefly, I mean, Mr. Mason can talk about some of the history of where the office has been with this, but like the Vice Speaker earlier this morning, I've been against gambling on our island, and as a private citizen, I've written against it, and as a prosecutor, I've seen problems associated with gambling, both criminal and socioeconomic. But as the Attorney General, my role is limited to what the law is and what is legal. And we've had the opportunity to review Bill 2032, both versions, especially now with the substituted version. And we look specifically at the funding source, and we do have an opinion regarding it. And our opinion is that the use of the revenue from illegal gambling devices would be illusory and illegal. Illusory in that such revenue really doesn't exist. Illegal in that it is based on illegal assumptions, that is, gambling devices are legal. Our two main bases are, one, the gambling devices are illegal and cannot be licensed, and two, well, there's no Guam law legalizing them. Two, the regulations cited in the bill are trumped by law, and they were improperly enacted. Regarding notice to the office, we went back and looked at the contact that we've had with your office regarding it, and unfortunately for the hearing yesterday, the notice was sent to our old email address, and so we did not receive it, and we scoured our records and could not find a record of being notified of the hearing. When we checked with your office, we found out that someone had sent it to our old address, and that our new address has been out, published for a while. In fact, the prior hearing in March, we got notice of the prior hearing at our corrected address. So I don't know what happened between March and yesterday, but initially we received notice. As of yesterday, we did not receive notice.
Okay, so if that
So
was...
we didn't get a chance, I'm sorry.
Okay,
didn't get
so
a chance
if that
to-
was incorrect, you didn't know that the hearing was happening yesterday?
Did not know.
So the report was incorrect. Pacific News Center, Clint Rogel was incorrect in stating that he said that you would be at the hearing yesterday.
My recollection of that interview with him was that question wasn't asked. and I'd never
Okay.
responded that
And,
way.
and it was in the media. It was in the media, and so I don't know if you guys are staying tuned to current events and watching the news or listening to the radio, but it's been out there. And so I don't want to I don't want to take up time debating whether you knew about it or not.
Well,
So-
as I told you earlier, I did get on Channel 13 to look at the morning and the afternoon sessions and did not see what was happening. I did not know that this was occurring at 12:30. So I'm only telling you what I know and what I know and what I didn't know, and I didn't know. My office did not know. We were all surprised that the hearing was held yesterday. We have an opinion about it. We were ready to give that opinion, but again, we weren't. We didn't have the opportunity.
Okay, thank you. I don't want to go.
But that's why
down.
we're here.
Yeah. Okay, thank you. You say that these are illegal. This is illegal devices, right?
Right.
These have been out since 1998. Is 1998 or 1999? I'm not sure. When and these had licenses before they were revoked in 2008, and even after it was issued licenses in April, if these were illegal, and I know you compared it to revenues for like illegal drugs and illegal firearms, if these are illegal, what have you guys done as the top legal law enforcement in our community to go out and take these down if they're illegal?
Well, as soon as we found out that the licenses were being issued, we made sure that we contacted DRT to find out what happened, and we had a meeting with them and told them that the issuance of these licenses were improper. And at this point, my recollection is that they are not doing that now. But currently, actually have a listing of the different devices out there and the different places, and so we are currently working our investigation, because at this point, under current law, we are not able to just go in and seize things that we think are illegal. I think there's some due process issues that need to be adhered to, and we're not jackbooted thugs that we're going to go in and just grab things that we think that we know are illegal. There's some due process.
So it's your position that you think these are illegal. It's not based on a judgment or a court saying that these are illegal. So it's just something you think that are illegal.
It's based
Because if
on-
it's illegal, like drugs or firearms, I'm sure you're going to go out there and take them down, right? So, and that's where I'm trying to get at, because we keep hearing these are illegal, but then they have licenses from the government to operate, right?
We still need warrants to go after illegal drugs, and there's still some due process that needs to occur, even if it's illegal drugs, illegal firearms. But there is a process, and we are going through that right now. Our opinion is not just what I think. Our opinion is based on law. There was even court opinions that said that these are illegal. So it's not, Lenny Rapadas or Pat Mason saying, "Oh, we think it's illegal because we don't like it." It's because under the law, gambling devices are illegal, and they cannot be licensed under Title 11. They cannot be licensed.
So these particular devices that we reference on Substitute Bill 20, those have judgments and orders saying that these are illegal?
Well, Mr. Mason discussed it, but there are some there's history back to 08, and I was in a different position. I'm up on it, but Mr. Mason knows.
Well, in the past, of course, we took action. We did an investigation with Rev and Tax. This was in '08. And we decided these devices were illegal. We met with Rev and Tax. They decided they were illegal. And so they revoked the license. And then a lawsuit was brought by one of the owners. And during that lawsuit, the then Lieutenant Governor issued an order to Rev and Tax to grant the licenses. Can you hear
Mr.
me?
Mason, if I may, can you speak a little bit closer to the mic so everybody can
Okay.
hear you? You're garbled.
So the then Lieutenant Governor issued an order to Rev and Tax saying, no, they weren't given due process. You have to give the licenses back. And so Rev and Tax gave the licenses back. Then what we had to do is we sued Rev and Tax to force them to revoke the license because they were illegal. Now, during the course of that proceeding, there was the answer that was filed by the other side was not valid. The judge ordered the devices to be, or Reventax to revoke the license forthwith, which they did. And then this owner moved to intervene in that case, and they were allowed to intervene. At the same time, they filed another case for a writ of mandate for Reventax to issue them their licenses. So there were two cases going. In both of them, the owner wanted to have their licenses back. And so they were suing to get their license back. They were intervening to try and overturn the court's decision that revoked them. Okay, those were going. Then that owner decided that they were not going to pursue those further. Remember, in both cases, they were trying to get their license, be authorized to issue licenses, and they went to the court to get that authorization. Well, those cases were dismissed, so they gave up trying to get the authorization. Then we were not informed, although we had been the lawyers for Reventax, that they were going to then issue the licenses. And so recently, they started issuing the licenses, which caught us very much by surprise. And so then we sent letters to Reventax to tell them to stop issuing those licenses and don't renew them because they're illegal. We had already gone through this with them when the first actions were filed. And so that's where we are here today, you know. Now they have licenses. We can't go out and seize machines for which the Department of Revenue Tax has given licenses. So we intend to take appropriate action from here forward because these devices are not legal. And I think that the bill that we're addressing here today, the bill refers to companies involved in gaming. And gaming, this type of gaming is not legal on Guam. And then it mentions some regulations, not a law. And then it says all licenses issued pursuant to the licensing law for revenue and taxes for amusement devices. And then it mentions the name of some of those devices. They're Liberty Symbolic Match Play. Shall be those are, and they call them electronic gaming devices. And the ones that had licenses before August 1, 2001, this seems to indicate those were entitled to be licensed, and now we're going to tax them. That appears to me what this says. Now, it's a little ambiguous. And one thing that jumps right out at me, they say Liberty Symbolic and Match Play. So they name some of the devices that were registered before, but not all of them. They leave out one.
Yeah, that's because we got information from Reventax asking them what are the devices that were registered prior to August 1st, 2001. And so those were the only ones that we were provided that are registered. And so that's why we're making it clear that these are the only ones. We're not opening it up for any additional devices. Only the ones as per the rules and regs, that these are the only ones that were authorized to be licensed.
The list we got from Reventax had at least one other called Uncle Sam. As far as I know, most of these are the same, except, you know, the facade is different. I mean, the inner runnings are the same. That's my understanding. I'm not an expert on this. That's just what I've been told by one of the owners. So, so anyway, I think it's unclear because they're saying they're gaming devices, and they're saying the gaming devices that are described in these regulations. Okay, so what is Reventax allowed to license? And this is what started the whole ball rolling back in '08. And the law is 22-202 of 11 GCA, and it lists the gaming devices, or the amusement devices, excuse me, and the fees. And then at the end it says, no slot machine or amusement device set to make progressive or automatic payout shall be licensed, so slot machine type games. And then it adds, no gambling device as defined in 9 GCA 64.20b shall be licensed under this section. So that's the criminal law. That's a reference to the criminal law. And so when you move to the criminal law, you find there's sort of a catch-all section at the bottom that includes, it says you cannot, these are illegal. And any slot machine, video poker machine, and other machines or devices which afford the opportunity of winnings, payouts, malfunction refunds to the player, or giving the player or user anything of value under any guise or form based partially or completely upon chance. And so our prior investigation indicated that those devices were illegal based on this definition.
Have you investigated any other gaming devices?
Pardon me?
Have you investigated any other gaming devices besides the ones we're talking about today?
Well, we just, back then, we just would, you know, they were all over the place. We couldn't investigate. You know, not like all, I don't know, 1,000 of them or something, but we went and played at various places and determined that they were illegal. And Reverend Tax, when we showed them our investigation, they agreed they were illegal. And so that's what the state of the law is now.
So, sir, I guess my question is, and you referenced it earlier, has a court determined that these machines that we've listed in the bill, have the courts determined these are illegal?
No, but the law has. The
No.
duly enacted law.
No, I know what the law says,
has
but has a court determined that these machines that we're saying we want to capture to capture their tax revenue for the hospital, have these been determined to be illegal? Because that's the question I guess the body has, is that have they been determined to be illegal?
Well, we said that they're illegal by law.
No, because you were in court for 5 years,
Well,
right?
well, you're saying that every law that's enforced, you have to go to court to determine it? I mean,
No, I'm not saying that, because you've been in court for 5 years.
here too, there's the fact that what you're saying is you're referring to these regulations.
Mr. Mason, can you please, we can't hear you. Can you please speak closer to the mic?
This is kind of, oh, it was off. Oh, okay. So here's why I think the law is ambiguous, and at the very least, and I think it has to be clarified because it refers to the licensing of gaming devices under these regulations. Okay,
So-
and
so-
those regulations refer to gambling devices, gaming devices.
Sure. So in the 5 years that you guys were in court before you dismissed it in April or sometime this year, did the courts was there any judgment saying that these devices are illegal?
No, I know of no court order determining these vices to be illegal. Now we went through this in 2002 or 1, and they were different devices, but
But
they,
these
they fit
devices
the
that I list,
definition, and they were illegal. But no, there's no court. But certainly the investigation we've done shows they're illegal.
yeah, sure. No, and I hear you there. So all I'm
But-
asking is that whether a court has said it's illegal because I want to use it to fund the hospital, and I'm being told that you can't do it because these are illegal. And so
That's right.
yeah, and so I just want to know if a court has determined that these are illegal. And I asked that, and I don't expect you to go to court for everything to enforce. I asked that because you were in court, I believe, for 5 years on
No.
this issue.
I guess the Attorney General's job is to look at the law, find out what it means, and assist the agencies in enforcing the law. And that's what we do, and that's what we're doing here. I don't think we're required every time we run into something to say, okay, it's illegal, but we better go file a motion for a declaratory judgment to make sure it is illegal. That's not our role here. Our role is to look at the law, and if we investigate the facts and determine if it's legal or not. Now, Reverend Tax earlier agreed with us, and their job is to enforce the law also. So there was a change when they issued these licenses. Reverend Tax changed from their prior view of saying that in conjunction with our investigation, these were illegal devices. So there's a change. So my feeling is if we need to raise revenue, we being the island, people of Guam, which of course we do, and we want to do it by authorizing what's called right here the use of electronic gaming devices, then I believe we should just say we're authorizing the use of electronic gaming devices on Guam, and we're taxing them X amount of dollars, X percent. But I think this talks about gaming devices, and as the law stands now, electronic gaming devices are not legal. And there's I guess a whole factual argument. You're saying, gee, these aren't electronic gaming devices. Well, our investigation shows that they are.
So the language you're saying we need to include here is that we're saying that that these gaming devices are authorized.
Yes.
So that's all we need to do to make it where we're affirming its legality, because they have licenses. And so maybe we need to hear from Reverend Tax, and if you're saying if that's all we need to do, then that's a simple amendment.
I'm just saying, if you clearly state, all I do is interpret the law. I'm
Yes.
not talking about policy and my personal feelings about gambling.
Mhm.
I do have personal feelings, but that's neither here nor there.
That's right, and so do I, and so we know, and that's not why we're leaders on this island.
And so, if this were to say that electronic gaming devices, and then to define electronic gaming devices, you can even pull the definition out of, these regulations you cite, which I believe are, since they violate the law, they have no force and effect.
Mhm.
But there's a definition in there. You
So
pull
on-
it out,
on
put it in there,
page-
and say these gaming devices are now, are legal.
On
You could do
page
that.
page 14 of the bill, the substitute bill, we can turn to section 7. Or I'm sorry, section 6.
Section 7,
Section 6.
Section
6,
8.
where it amends 22-202, Title 11, Chapter 22.
8122.
No, 22-202.
Oh, you're talking about the statute. No.
No, on the bill.
Okay.
Page 14. Are you on page 14?
I have no page numbers on
Oh, you
this.
don't.
I'm
So I don't know if he
sorry.
has. Can we make sure he has the correct? Thank you, Senator.
Okay.
Yes. So
I have page 14.
and so
so-
does that? I mean, is this one here now? Will that satisfy what you were just talking about? About saying that we're authorizing these devices?
This says electronic gaming devices authorized by these regulations. Well, as I said, these regulations, first of all, they weren't properly adopted as regulations. I must say that. And secondly, they're not, these are not legitimate regulations because they violate the law. So if you're bringing in regulations, if you're saying that we hereby enact into law these regulations, then that would be duly enacted law. But if
So you're saying these regulations are not? I mean, I don't know. If I
these
understand.
regulations if a regulation and a law are in conflict, you have to follow the law and not the regulation. And what I'm saying, first off, is that the law, which we've just referred to, is in conflict with these so-called regulations. Therefore, the law prevails. So we have to make these regulations the law, and you can't do it by amending regulations. You have to do it by duly enacted law. That's what I'm saying. Gaming devices are currently illegal by duly enacted law. Now, these regulations authorize gaming devices, so they conflict. So you can't amend you can refer to regulations, but those regulations conflict with law. You have to adopt those regulations as duly enacted law if you want the whole thing in there as part of Guam law, and then that would amend the current law against licensing gaming devices. So, you certainly could do it that way.
Madam Chair, point of inquiry.
Senator Limchialco, please state your point of inquiry.
Could you kindly cite the law that you're referring to? We're talking about the regulations right now, but what law are you referring to based on your definition that the gambling devices are illegal?
Okay.
I don't think we're under the understanding of which law you're referring to.
Okay. First of all, I'm referring to 11 Guam Code Annotated, Section 22.202. And what that does is that states the amusement devices that Rev and Tax can license. And if you look at the last sentence of that statute, it says no gambling device as defined in 9 GCA section 64.20 subsection B shall be licensed under this section. And so that's a reference to the criminal law where the definition that I referred to before is found.
Thank you, Senator Limchialco. Senator Rodriguez, you still have the floor. Did you want Rev and Tax to quote, because you asked for Rev and Tax earlier? Did you want them to?
Sure. If you can just, based on what he just said about, if you can tell us how these licenses were issued under what statute, or under what basis?
By Department of Revenue and Taxation pursuant to Title 11, Chapter 22, Article 2, prior to August 1st, 2001.
Okay, so based on that, Mr. Mason, that's the basis of them issuing the licenses. And so, and I asked earlier whether there was any court judgment about these particular machines, and so we know there wasn't any. So how can you help me now ensure that what we're doing here affirms what they have done?
Well, because it's in conflict. The law does not authorize gaming devices to be licensed. So we have these regulations, which I guess were submitted in '02, but were first published on the compiler's website in January of this year. Those conflict. Those two conflict, and that's what I'm saying. They conflict. Gaming devices, those regulations say gaming devices, electronic gaming devices are proper. It says bingo, cockfighting, dog racing, public lottery or carnival, and then this is a new one that isn't in the law right now. Electronic gaming devices that have been registered or were registered prior to a certain date, which of course, I don't know about equal protection, but limits new people from coming. It kind of gives a monopoly. But that's an aside. But so that those two conflict. That's why. That's the first reason. The second reason is they weren't properly adopted. There was no when they were submitted as regulations back in, I think it was '02, that there was no financing statement and there was no record of a public hearing.
I have no questions right now, Madam Chair.
Vice Speaker, next to speak on the agenda is the Vice Speaker. And just for those who wishing to speak, I also have Senator Mike San Nicolas also wishing to speak, and Senator Michael Mtiaco. So Vice Speaker, you're recognized for questioning to the panel.
General, do you have a written opinion on this issue?
Okay, Vice Speaker, we have a letter that we had written to DRT soon after we found out that they had done this, and right now I believe that's all we have right now is a letter to DRT, but the letter that we have can be easily converted to a memorandum to this body regarding the legality of these particular machines.
I think it might help if you read that into the record. Have the general read it, please, because we're having problems with your voice, Pat. No offense.
Well, the letter that we have is a letter to the Director of Revenue and Taxation. At this point, I'm not certain that we may be violating any attorney-client privilege, so we may need to get a waiver from the director right now for me to do that. Otherwise, we can very quickly do an opinion for this body.
With all that's been happening with this issue, your office has not deemed it necessary to prepare a legal opinion on this issue?
We were
You're publicly fighting with Rev and Tax and threatening to go take them to court, and you've not issued a legal opinion?
We've issued a memorandum directly to the director, so that because they're the ones that take the direct action. So we went straight to them. So we are currently working with them to make sure that they comply with the law. We've sent them the letter, and so they've got the benefit of our counsel. So hopefully they'll be following it. But there wasn't a broad opinion. Opinions are different from the actual memorandum that we send to the.
I understand that.
Right.
And I'm just saying, with all of this going on that has been going on for the last 5 years, neither you nor your predecessor has deemed it necessary to prepare a legal opinion on this?
But the letter was directly addressing these particular gambling devices that had the licensing of these devices. There might be some others that we've addressed to, I guess, Bill 19-32.
Not 19. I'm just talking about, you've been in court for 5 years over this issue, right?
Well, yeah, of course, I've probably briefed these issues at least 3 times, and I've initially, as far as opinions, directing the agencies what they should do when we found out these devices were being licensed back in '08, '07, we immediately did an investigation and issued an opinion to Rev and Tax. They responded, we shared our investigation, and then they revoked the licenses. So we have definitely issued an opinion to the Department of Revenue.
So is there a legal opinion that could be provided to us that we can read? I'm sorry, but I really am more visual than I am in trying to listen to either one of you.
Yeah, okay.
So if I had it in writing in front of me, I could follow the argument a little better.
We did
Even
issue a
the
letter.
P&A that was filed in this case would help me better than listening to either one of you.
Yeah, Mr. Vice Speaker, we did on February 25th, 2013, issue a letter that went to the chairman of the committee, Senator Pangilinan, and then we sent a copy to this was regarding certain issues raised by you, Senator Chris Duenas and Senator Morrison.
That's 19.
Yes,
Talking about
yes.
gambling
Vice
devices.
Speaker, I'm just going to add to the record, Director Camacho has a comment based on how those licenses were issued, so you want to go ahead and state?
These licenses were recently licenses that were issued in April was based on knowing that the case was dropped in court, and when we look at the regulations that it allowed, basically these electronic gaming devices that were registered previously on or before August 1st, we strictly look at those machines, and those are the only machines that we allowed to be licensed.
Okay, are you stating a point of inquiry, please?
Yes, I'm just concerned. When the Attorney General pointed out none of the laws changed, so when the Attorney General originally advised Rev Tax back in 2008 that everything that exists today, the machines are illegal, revoke the license, you revoke the license.
We didn't revoke it. I believe we gave a notice to not renew it.
Okay, so the license were not renewed based on the advice of the Attorney General at that time on everything that exists today, and nothing has changed since then. No new law was enacted, no new interpretation was issued. It was just the lawsuit was dismissed, but no laws were changed.
Well, the case was dropped. I mean,
Yeah, but the laws didn't change, and you revoked the license based on the law.
no, we didn't revoke it.
Or you did not renew the license based on the law. And there's been no other law enacted.
I'm going to ask
Since
if
then.
the media room can please turn up the volume on the panels. Did you want Mr. Camacho to repeat his statement, Vice Speaker? Okay, I did have if we were at a point of information, Vice Speaker still had the floor. Is your question, is your point of inquiry or information satisfied?
If there is a legal opinion, would somebody please read it to me or provide me a copy so I can read it, or P&A, something that can help me rather than the ramblings of the two of you?
Mr. Vice Speaker, I just spoke to the lawyer who was working on the memo regarding this bill. She happens to be here today, and she's almost done. She wasn't quite done, and we didn't know about the hearing yesterday. Maybe we should have. I don't know, but that will be at least within 10 days of that hearing. That will be finalized shortly, and that was assigned, Mr. Vice Speaker.
You might be able to save yourself the time. This is going to be passed by Tuesday.
Right. There was going to be a response by our office to the bill had we had a notice of the hearing. Unfortunately, again, we didn't, but we have the memo essentially done, so it's ready to be given to the legislature.
Madam Chair?
Do you have
Yeah.
a point of information?
We can get it to you by close of business.
Majority Leader, do you have a...
Yeah, thank you, Madam Chair. I'm just also trying to follow the discussion, and I am following very closely what the Attorney General's office is providing to us by way of guidance. You remember he said that in 2008 they initiated the investigation based on the law at the time, that their ruling was that was an illegal activity. Now the question that everybody keeps asking, what changed to require Rev Tax to proceed with the issuance of these licenses? I think that what we have to recognize is the thing that changed was the promulgation of those rules and regs that authorizes those licenses of those machines. And I want to ask Pat Mason, Attorney Mason, if he recalls at the time when we had another former Attorney General, and we were discussing the Integrated Solid Waste Management Plan, and how that plan was adopted by way of rules and regulations that was promulgated. And at the time, we asked, well, there was no economic impact statement, there was no environmental impact assessment, or there were some things that were deficient with the rules or with the laws that required, that should have been elements of those, that particular rules and regs, or all rules and regs. And the Attorney General's office at the time told the legislature that it didn't matter what was deficient up until the point that the legislature took action on it. And so because those rules and regs were ultimately promulgated through the AAA process, and the legislature at that time didn't act on those rules, so it was default to approval, that those rules and regulations were the law of the land. And this law that required the promulgation of the rules and regs which authorized the license of these machines, wasn't that by way of a law? Wasn't there a law that required that Rev and Tax promulgate these rules? And then so those rules were promulgated, submitted to the legislature, and they were never acted on, so they became approved by the legislature. And so, but they weren't recently codified until recent, when Rev and Tax now believed they had standing to go and issue those licenses. I invited the Governor's Legal Counsel in because I do recall your public comments, Attorney Miller, about why you believe that the government of Guam had standing, notwithstanding the Attorney General's position in this issue, to issue those licenses. Is that what changed? What changed was the promulgation of those rules and regs, which now, by those rules and regs, required Rev and Tax to issue those licenses?
Yes, sir. Thank you, Senator. What happened was, and the Attorney General has stated here that he disputes it, was the promulgation of the gaming rules and regulations. The gaming rules and regulations were promulgated and authorized specifically by Public Law 26-52. Now, let me read what 26-52, Section 4 says. And this is a legislation sponsored by Senator, I believe it was Senator Frank Uggan at the time. And it says, notwithstanding any other provision of law, the Cockpit License Board and Rev and Tax are hereby authorized to promulgate necessary rules and regulations to create a comprehensive regulatory scheme to regulate all gaming activities, provided that this comes in before August 1, 2001. Now, that word notwithstanding any other provisions of law is important, because it says it doesn't matter what there is in the other laws. This is what we say today. Notwithstanding, Rev and Tax go out there and promulgate rules and regulations to create a comprehensive regulatory scheme for all gaming activities, not just cockfighting, not just bingo, everything else. And on those orders by this body, the 26th legislature, that's what Rev and Tax did. Now, it's always presumed that the legislature knows what it's doing when it does it, and that the law it passed back on the 26th was legal. So to say that the rules and regs promulgated by Rev and Tax are illegal is basically to say that Public Law 2652 doesn't mean what it says, that that body didn't mean this, and that basically this is just, it's just fluff. It has no meaning at all, and we should just ignore it. And I don't think that's was the intention at the time. So when you go back now into the rules and regs that Rev and Tax did promulgate pursuant to this authority, notwithstanding the AAA, notwithstanding any other provision of law, it clearly says.
But can I ask you just to pause for a minute? So that law in itself does not authorize the issuance of those licenses. What that law told Rev and Tax to do is to promulgate rules and regs to allow Rev and Tax to regulate all types of gaming and then issue those licenses accordingly. And so what changed again is although that public law said for Reverend Tax to do that, those rules and regs were not codified until recently, and upon the codification of those rules and regs, it was Reverend Tax's position that they now have the standing and the position to issue those licenses. So I'm trying to determine what changed, because there's comments that the law is the law, nothing changed in the law, but what changed was those rules and regulations that gave them the authority, in their opinion, to issue those licenses.
Yes, sir. Well, two things happen, and that's correct. The law is the law. And public law,
And your
2652
notwithstanding took care of the Attorney General's concern where they said there's a conflict with the prior law that said there's no, these activities are illegal.
Yes, that's my opinion. I mean, all I can go is by the plain language of the law that was written by this legislature, by the 26th legislature. And when the 26th legislature said, notwithstanding any other provisions of law, I just personally, you know, as an attorney, have to take that to mean what it says. So based on that authority, the two things that happened were Public Law 2652 passed, and Reverend Tax took its authority and did what it was told to do, which is to promulgate rules and regulations. It did that. Those regulations came here, they were fine, they got codified. Now what do those regulations say? That's the next question. So we look now at the regulations, and it says as long as certain gaming devices are in before August 1, 2001, which is a grandfather date, then they're fine. And, you know, that it just says what it says, and that's all we can do is to read the plain language and apply it to the facts. It's interesting, at least, you know, to me personally, sir, that there's such a debate about this, and that this was even in court for 5 years, because it shows that it's not an easy question. It's very complicated, and there's been no court ruling to say that these machines are gaming machines, that they're gambling machines, or that they're illegal. There's nothing. On the contrary, there's everything to say that they're fine, that they are, that these particular machines, not all gambling machines, and I'm not taking a position on gambling, you know, I too, like Pat Mason, have my own opinion, as we all do, is that it, you know, if you lay it all out, and you follow the law, and you follow the chronology, the machines, these particular machines that are referenced in Bill 20 are legal.
Okay, so I don't, also, Madam Chair, I don't mean to put the Reverend Tax Director, but thank you, by the way, for that explanation. I don't mean to put the Reverend Tax Director on the spot, but a couple of weeks ago, we had an oversight hearing conducted by Senator Nicholas, and he asked you the question relative to your disposition on those machines that you recently licensed, and you said that you were not going to renew those machines. Come July 1st, though those machines will not be licensed. I want to ask you, well, nothing apparently changed because as the Governor's legal counsel said, the rules and regulations that were authorized by law that told your agency to do these rules and regs were ultimately adopted by the legislature, and you issued licenses, but you said publicly that you weren't going to renew those licenses. Is your position still the same?
Basically, when we issued that, like I said earlier, we were relying on this regulation, which the Governor's Legal Counsel mentioned. At that point in time, the AG was communicating with the Department of Revenue, telling us about these machines. And at that point in time, we were looking at it, and we spoke to the AG, and upon consultation with further legal, looking at the law, we're saying that now these particular machines that we're only limiting for those machines that were registered on or before August 1st are legal. So, meaning now, I'm saying they're legal now until such time they're declared to be illegal. That's what I'm saying.
And I think you also said that you kind of wanted clarification in the law, if necessary, because you didn't want to have to go again through the administrative process of when licenses were revoked or have this thing litigated in court. So I think, is it the department's position that those rules and regulations are the rules and regulations that were promulgated ultimately, so they're your administrative law of the land?
That's our position right now.
Okay, before I give up the mic, Madam Chair, I asked former Senator Randy Cunliffe, but he's not here as a former senator. We do have a couple of former senators here, and I just want to quickly acknowledge Vice Speaker Ted Nelson. I believe Senator Talatagui is still here. But as someone who's been very public about this issue and all the litigation and the back and forth, I want to give Attorney Cunliffe an opportunity to give his thoughts on where we're at up until this point.
We'll do so. Senator Cunliffe.
Thank you very much, Madam Speaker. Thank you, Senator. Those of you who have been in the legislature some time understand that one of the problems that we run into in the legislature is the language we use and from one bill to another bill. The criminal law, 9 Guam Code Annotated, talks about gambling. The Public Law 2652 uses the term gaming. And so, although we're talking about the same thing, we're using two different descriptions of the instrumentalities that we're using. It would have been perhaps more appropriate either to change the gambling section in the 9 GCA or use gambling instead of gaming in 2652. But we have two different words which I believe describe the same thing. Now, I agree with Ms. Miller that 2652 clearly said revenue and tax shall prepare gaming rules and regulations for all forms of gaming that goes on, including the carnival, including all of those issues. And they shall restrict that to everything except machines that were authorized prior to August 1st of 2001. And so revenue and tax did that. And in the language of the bill that is before you, they cite the section that talks about, quote, gaming devices. These devices have always historically been registered through revenue and taxation as amusement devices. And under section 22.202 of 11 Guam Code Annotated, they have always been exempted from the gambling laws. Mr. Mason said that 9 GCA 6420 makes these machines illegal. That's not what the law says. 6420 says you cannot import gambling devices. It doesn't say gambling devices are illegal. It says you cannot import them. Now, 6410 defines gambling, says this is what gambling is. So once you know what gambling is, then you know what a gambling device is. But 6465 exempts all machines that are licensed pursuant to 11 GCA 22202 from gambling. They're not considered gambling devices. They're exempted. So the inclusion of these machines under 22202 takes them out of gambling, and right in section 6465 says you can wager on these machines. So in 9 GCA, the law clearly understands that there are some gambling devices and there are other devices which you're allowed to gamble on, but they're not gambling devices. Okay? And that's what the law says. So the situation here is the Department of Revenue and Taxation in 2002 submitted the rules and regs as directed by this Guam Legislature. The Guam Legislature, in the 27th Guam Legislature, because the legal community was not happy with things getting published in a reasonable time, directed that the compiler of laws to codify all rules and regulations that had been brought before the body before the beginning of the 27th Guam Legislature and put them into the code books. Unfortunately, the compiler of laws didn't do their job, and it took 10 years for them to finally do it. But that didn't mean it wasn't law. You just couldn't find it on the books because the 27th Guam Legislature had passed it. So the situation is such that these machines, in my legal opinion, are legal. And the attorney generals, of course, can disagree with that, and members of this body can agree and disagree with that. But the situation is, as Mr. Mason said, no court has said these machines are illegal. However, in a previous case, a court has said that machines that are listed in 11 GCA 22.202 as amusement devices are legal to gamble on. So the precedent is that if these are attached to 9 GCA 22.202 as amusement devices, because you now got amusement, gambling, gaming, the previous court case has said they are legal and they can be operated in that fashion.
Thank you, Madam Chair. Thank you.
Okay. Thank you. Next up to speak, I will entertain Senator Mike Nicholas, then Senator Mike Limchiaco. Senator Mike.
Thank you, Madam Speaker. You know, I'm just very concerned at this juncture because we have two different parties talking to this body, and we are not a court. And so whether or not gaming is legal or illegal is not going to be a decision that this body is going to be making as a ruling. I think what we need to clarify here is the true issue of concern regarding Bill 20, and that is whether or not this body can deliberate on and pass legislation that's going to tax something that has been licensed by this government. And so I wanted to ask a couple of questions, Madam Speaker, to fully determine whether or not we're able to do that. And if we are, I believe that would resolve this whole question of whether or not we can move forward with Bill 20. Because the underlying question really is, are we allowed to introduce a measure to tax something that is licensed by this government? And so my first question is going to be for the Department of Revenue and Taxation. Mr. Camacho, Director Camacho. There is a law in the books that says that a business shall not be licensed if they owe taxes to this government. Do we have businesses that are currently licensed to operate on Guam that have outstanding taxes due with no payment plans or anything else provisioned?
Yes, we do, sir, but this year we...
Honestly, John, all you need to yes or no.
Yes.
Yeah, okay. So if we have those businesses that are licensed to do business on Guam, but they owe taxes, I'd like to ask the Attorney General, then, are we still authorized to introduce legislation to tax those businesses?
You're saying that we go ahead and tax businesses that are already subject to tax?
If we have businesses, in order to be able to renew your business license on Guam,
Yes.
you need to pay your taxes.
Yes.
And if you don't pay your taxes, the law states that you shall not have your license renewed.
Yes.
The Director of Revenue and Taxation has already confirmed that there are businesses that haven't paid their taxes that have had their business licenses renewed. So if we were to introduce a bill to tax those businesses, would there be anything preventing us from entertaining that type of legislation?
Oh, yeah, you can introduce a bill to tax those businesses.
Okay.
I mean, even though they haven't followed the law, they could still have their business license taken away. But it seems to me if you're taxing them, you're in some way are legitimatizing them, and that's where the you know, it becomes ambiguous. You know, if you take something that's illegal, or well, that we think is illegal, and use that as a basis for taxing, are you legitimizing that? I understand your question. It seems to me, in this case, you need to be straightforward and say either this is legal or it's not legal, because there's so many arguments here, and as you can see, these arguments are all, they're presented before the court, and, I have arguments on these rules and whether they're legitimate, and Mr. Cunliffe has arguments. But really, the thing is, clear legislative approval of something trumps everything. So, but what I'm saying is when you refer to these regulations, you're being ambiguous. And I don't believe these regulations have the effect of duly enacted law because they conflict with current duly enacted law. See, that's my position. Now, if this body were to say, okay, what we're doing is, we understand that, but we're going to tax them. Well, first you have to, get rid of the ambiguity. Are these duly enacted? Are these machines out there pursuant to duly enacted law or not? Can rev and tax license these or not? And if it's straightforward, it's in the law, it's clear, then I think it's clear.
Now, I just wanted to clarify something because according to this report that I've been working with on rev and tax, we have 18,339 businesses that have accounts receivables owed to this government, which means that they have taxes owed to this government. Now, maybe some of them have payment plans, maybe some of them don't, but if the law states that they shall not have their business licenses renewed, and if these 18,000 have their business licenses renewed, which they have had over the years, then, from a legal standpoint, those businesses are all operating illegally. And so if they're all operating illegally, then therefore are we unable to entertain any kind of legislation that would tax those businesses? Now, of course, my position is that we still should be able to. If anything's duly licensed by this government, this body should be able to tax it until such time the court rules that those businesses should be closed. Now, right now, we have not had any court ruling as to whether or not the gaming devices need to be shut down or confiscated or what have you. They have been duly licensed by this government. The question now becomes for Bill 20, are we able to move forward and entertain whether or not we're going to be taxing these devices? Now, because we're not a court, guys, we're not going to be able to make a ruling here of yeah, they're legal, yeah, they're not legal. Ultimately, the only question that we need answered is if the business is duly licensed, are we authorized to entertain any kind of measure in law to tax them?
Yeah, that would seem so.
You're asking me if you can tax illegal businesses, I guess is the question. And I suppose the legislature could tax illegal businesses, but of course we can shut them down. You've kind of got me stumped, really, because usually if they're illegal,
We don't see that sort of thing.
you don't tax them. If Rev and Tax come to us and said, hey, these guys, we want to grab their business license because they're not paying their taxes, well, we would assist them with that. Can you tax an illegal, a business that's operating illegally? It seems almost like it'd be a fine more than a tax.
That's supposed to be a different other penalty, well, not a penalty, but a different way to deal with that.
Yeah,
Not-
I mean,
not to
and
tax them.
the other
Because
thing
then
too.
again, it opens up the issue that Mr. Mason brought up. Are we then legitimizing the illegal business?
No, we have a
This
potential
body-
18,339 other occurrences of that besides this one activity. My other concern, I mean, on the same basis is, there's a law in the books that says that we shall not issue alcohol licenses over a certain limit, but we've clearly issued 50, 41 in the municipality of Tamuning and 9 in the municipality of Hagatnya that were over that legal limit. I sent a letter to your office, by the way, to help me clarify that.
Right.
And what's going to happen to those businesses? And see, what's scaring me, Mr. General, is I'm also now worried about equal protection of the law. And we're going to be getting into a whole other issue here, but if the law says that those businesses are illegal and we're going to go out and shut them down, what about all these other instances of illegality and enforcement? So I think that we need to step back, Madam Speaker. We're not going to be able to determine whether they're legal or illegal. I think what we need is just a firm answer from the Attorney General as to whether or not we can entertain legislation to tax businesses that are licensed by this government. And if we can get a firm answer on that, I would like for us to consider resolving out of a committee of the whole after that determination. Mr. General, are we able to tax businesses that are licensed by this government?
I need to go back and to go back on the one question that was asked by the Vice Speaker on whether or not we had an opinion on this particular issue. Actually, what our staff was working on was a response to the mayor memo that you had asked us to opine on, and that was what we were working on to give this body some guidance as to the bill. Right. So our response to that the mayor memo. Right, and we need to
Senator, just so that our listening audience can please speak into the mic if there's a.
Okay, no, I
if
was
you
just
have a
saying
point
that
of
yes, we do.
information.
We do have that response from your office, and it's part of the committee report.
right.
Thank you, Senator Rodriguez. Senator Sinicla still has the floor, so.
And that memo didn't actually specifically address this issue, which we intend to address for this body to make it clear what our position is. So we didn't address it specifically in that response to that memo, but we will do that. But again, we don't. That's a policy issue that you may have to take. In a sense, you're providing kind of an amnesty for these businesses, these illegal businesses who haven't paid their taxes. So that's something that this body has to think about and make a policy decision on.
But the reason why I brought all of those up is referencing Bill 20 then. Bill 20, from what I've read here, not discussing the merits of the funding source at all, is strictly talking about taxing an enterprise that has been licensed by this government. So are we therefore able to move forward now with Bill 20 and make a determination whether we're going to vote for or against this bill, seeing that we are already in practice taxing 18,000 plus entities?
I'm of the opinion that this body should have as much information as possible before it makes its decision. And right now, I think at this juncture, this body doesn't have the full benefit of the Attorney General's opinion on this issue. And we would love to do that, and we want to provide that to this body before they make that decision. Of course, you can make a decision based on whatever information you have as promulgated, as enacted, as approved, or however it comes out. If we determine after its enactment that there's some illegality that we need to address, we will address that as it done, and we've mentioned that outside to other parties.
But by virtue of taxation of an entity, are we thereby legalizing it?
That is the question, and that's the question, and I thought about that before I came here. I think, well, now, wait a minute, they're taxing it, so are they legitimizing it? And that is, to me, it's ambiguous the way the law is written, whether you're legitimizing it or not. It could be argued both ways, but, I was thinking we would probably ask for some kind of a declaratory judgment, but it would seem that from some of the language, you are legitimizing these gaming devices.
But just to clarify, though, we have not already defined whether they're legitimate or illegitimate. The court hasn't even ruled on that. And so we have two different opinions, whether they're legitimate or illegitimate. We're not a court, so we're not going to be able to make that determination here. So, I mean, referencing, like, for example, boards and commissions, right? When they make a determination based on what's available to them in information, even if it's contrary to Guam law, if it's in good faith, then they're able to move forward on that. So if in good faith we're unable to determine whether or not they are legal or illegal, and all we have to go on right now is that they are duly licensed, can we therefore in good faith tax those duly licensed enterprises and not be legalizing them? Because we don't know whether they're legal or illegal anyway. And the bottom line is they're already getting taxed. This bill is actually earmarking the tax for a specific purpose, but they are actually getting taxed.
Yeah, yes, I believe you're right. They're already taxed. And as I sit here, I can tell you that if we end up in court, Mr. Cunliffe will argue very vehemently that, the legislature decided, and the legislature decided that you could go ahead and license these and they would be taxed at this rate.
But from what I'm understanding, they are licensed. So
Yes.
John, they're licensed already.
Yes.
So we're not in this bill. We're not licensing them. All we're saying is their taxes are going to go to this particular place.
Yes.
They're already
We
paying
are already
taxes.
taxing them. It's just that, I guess moving forward, if the bill were to pass into law, it would go into the GMH trust fund.
So by specifying where the money is going, I guess to the Attorney General, by specifying where the money is going, are we further legitimizing something that is already technically operating legitimately and being taxed as a result of its current operations?
Well, in our view, you would be taxing something. You would be adding another category to the list of that's not in there already of things that can be licensed, and it would be gaming devices.
No, but we just heard them say that these devices are authorized. So we're not adding anything new.
Well, these devices, of course, are not listed under the items where it lists them 1, 2, 3.
No, but these items are what has been registered and licensed prior to August 1st, 2001. So these are already referenced in law.
Yeah, they were licensed in August 2001.
So we're not adding because it's very sensitive. You have people out there that are thinking that we are opening the floodgates. And so to say that we're adding something new, it's very sensitive.
Well, I think it's true. I think you are adding something new because you look down the devices, you look at the reg, it says electronic gaming devices.
That were registered prior to August 1st.
You look at
and so we asked Reverend Tax, what are these devices? What are the names of these devices? And so they gave us the names, and so we added here in this bill.
So have you added it? The law that relates to gaming devices is 22-202, and these devices are not listed in there. And those are the devices that Reverend Tack is authorized to license, and then there's an exclusion for gambling at the bottom.
Which these devices are what was authorized.
They're
prior
not in
to
that list. They're
No,
not.
they're not named, but these devices that it's referenced, that were registered, these are the devices. We're just making it clear that these are the only ones. So we're making it clear that we're not adding anything else.
Senator Rodriguez has a point of information stating back and forth. I'm going to ask the clarification of Reverend Tax to again state, so if you can inquire with Reverend Tax to state the position if the licenses were given because of the law that exists today that says that prior to 2001, just so ask him.
Yes, those licenses were issued based on, again, 3 GRA Business Regulation, Chapter 7, Gaming, under Section 7114A5. Basically, those. I just want to comment because Pat Mason brought up one machine that we overlooked, and we're taking measures to revoke that machine. The only machines that are involved from August, on or before August 1st, are the Liberty, Symbolic, and the Match Play. So we overlooked one, and I saw that earlier, and we're taking steps to revoke that license.
So John, we're not adding this bill as you read it, where we're saying those devices that you just named, these are already the ones that are considered licensable products. And so we're not adding anything new.
We're not adding anything. It's all, they were all registered on or before August 1st, 2001.
And it's also limited, the number.
And it's limited, yes.
Because, they can't say if they have 100 machines, just because their name, these Liberty, Symbolics, or Match, but they can't add any more. It's the number that was registered prior to August 1st, 2001. That's it. Nothing else.
Nothing else, yes, that's true.
Thank you.
So
Do you have a point
basically,
of inquiry?
basically, this bill is to license only those machines. And so basically, the government is now saying we're going to have a monopoly on these machines to those that are only existing and nobody else can have any other machine.
Okay, Speaker, is that a point of inquiry, and to who? To Mr. Camacho. Mr. Camacho, would you like to answer that, please?
That is what the regulation says. Basically, only those machines that are registered on or before August 1st, 2001.
And just a point of information, Madam Chair, this and that language, those registered prior to August 1st, 2001 is already in the books. We're not recreating it here. All we're saying is we're affirming that those are the only ones that are being, that are authorized to be licensed.
Again, yeah.
Um,
But the question is, the rule, the regulation that they're citing, there's a difference of opinion in the regulation that's being cited. One side is saying those regulations are duly enacted into law. The other side says those regulations are not. And I think that's what we have
Yeah.
here. The
Spe-
gambling control regulations.
Speaker Pangilinan, if I may, just because the question that was asked of Vice Speaker Cruz was if there was a legal opinion addressed to this body today, and because we don't have that legal opinion, I'm not going to assume that based on their assumption that something's being said. I'm going to take into consideration what's on the floor today, and I only ask that because this situation right now is real critical. The
Well,
question was asked, Mr. Speaker, if I may, the question was asked if any other machine, was there any other license given to any machine prior to 2001? And the answer was no. If there is a separation of the legal opinions from what is standing today versus what is assumed, there was a request on the floor. We don't have that opinion right now.
Then I
So the
would
point of
also-
information is if
Yeah.
you have another inquiry to
Yeah.
ask, please go ahead and do it at that time.
Yes, then I would also like to ask the Department of Revenue and Tax
Please proceed.
to give us a legal opinion or an opinion from anybody that said that these regulations are duly enacted and he should issue them under those regulations.
Okay, I do know that you.
Do we have anything?
Okay, the
Because
codification
because
from the 27th Guam Legislature?
Well, again, it's from Rev and Tax that I'm asking that because the Attorney General had said that they had discussions with Rev and Tax. They issued them a letter. Rev and Tax agreed that they would withdraw or not renew the license of the machines, and they would not issue any additional licenses, and they would not renew them upon expiration in June. And the Attorney General, relying on that, is now moving forward to revoke those licenses that have been issued. Then Rev and Tax says that they got a legal opinion from somebody else, and that's when they issued those licenses. So who is the attorney for Rev and Tax? Is the Attorney General the attorney for Rev and Tax? And when they had an agreement with their attorney, they went to another attorney, and another attorney told them, and then they acted on that. John, you mentioned based upon further legal discussion. Who were those further legal discussions with?
Well, like I said, when we issued those licenses, we relied on this regulation. I repeated it 3 times. This particular section, do you want me to say it again? It's section, okay, that section is what we relied on when we issued that.
But then the Attorney General wrote you a letter and said, you're doing them illegally, or we don't believe that you should be issuing these licenses. You agreed not to issue them. You agreed that you would then not to issue any more. You agreed that you would not renew them when they expire. And then you also said that based on further legal discussions, who were those further legal discussions with?
Well, basically, we agreed that there's no license to be issued,
Okay,
and we haven't issued any license since then.
right. And that you're not going to renew any licenses.
Basically, I renewed those licenses based on these regulations, and to such time, there's a law that says these machines are illegal, then basically uh, if nothing comes up next month and there's no law that says these machines are illegal, we will renew them.
But what if the Attorney General issues you a legal opinion right now that says they are illegal under the existing statutes without this additional language being enacted?
Basically, at that point in time, we will look at it.
I don't understand that.
Madam Speaker, I still had some further questions that I wanted to.
Please go ahead
If I
with
may.
your increase.
You know, I'm seeing us here getting caught up on one fundamental problem, and that is whether or not applying this tax is going to legitimize the operation, and that really cannot be answered without a court order or a court judgment. And so what I would like to ask is, can legal counsel assist the author in crafting the bill in a way that isn't going to be allowing this bill to further define the legality or illegality of the operation? In other words, can we say something to the effect that without further defining the legality of the operation, we hereby assess this tax? That way, we can move on from this committee of the whole, stick that into the bill so that there's no question as to whether or not it's going to be legitimizing the operation, and move forward, because I don't see us moving forward without defining something here.
Again, you know, that is such an interesting question that neither of us have an answer at this point right now. I mean, is this a slope that we want to go down? Are we legitimizing illegal businesses? Do we want to do that? We don't know that. We need to research that more. And we have issued an opinion to the Department of Revenue Tax. I don't know why he's saying that we don't.
John, do you have that opinion? He says that he issued an opinion to you,
A memorandum.
or a memorandum.
A letter? Yes, I received that memorandum, and we were in discussion with them on that particular letter. And to such time, basically, we look at these regulations, and we're saying this, that we properly, basically, issue those licenses based on these regulations.
So I'm confused because you said that you would, so basically you're ignoring the advice of your attorney who had told you that these machines are not illegal and are not legal, and that you should not be issuing them even under those regulations, and you agreed initially, and then based upon further legal discussion, and I still want to know who those further legal discussions with. Who else, John, after you talked to the Attorney General's office and discussion of that memorandum or the letter, and then you decided, and you, in an interview, I guess, also said that you would stop issuing the license, that you would not renew them based upon those, on the existing regulations, because that's what the regulations are. And then the bill here changes those regulations or clarifies those, I guess, to ensure that they are then can be interpreted in some form or fashion to be legal. And so again, I just want to know, who was the additional legal discussions that you had that caused you to ignore the advice of your attorney? And is the Attorney General's office the legal representative for Department of Revenue and Tax?
Attorney Cruz said she'd answer that. I mean, Attorney Miller.
I would have Sandy Miller, the legal counsel for the government, answer that question.
Yes, thank you, Senator, for your question. Actually, what happened, what you're saying is not quite correct. What happened was, after the cases were dismissed in the Superior Court of Guam, therefore they went away, Rev and Tax was approached with an application for licensure. At that point, with no case hanging over their head, and all we have are the regulations saying that they're legal, they inquired of me personally, can we issue these licenses? I read this and I reported the same thing that I reported to you guys just a little while ago, which is that, to me, they were legal.
Yes, and that's all I wanted to know. Who then, after the discussion with the Attorney General and Mr. Camacho, in which he agreed that they were not, and then the case was dismissed,
Yeah,
who
but he
who then advised him to go ahead and issue the license?
He-
That was you,
Yes,
out of the governor's office?
yes.
Okay, that's all.
Reventax asked, the case is dismissed. This was the
Yeah.
chronology, and
Right.
it's important.
Yes, yes, absolutely.
Because the cases were dismissed, the field was wide open. Once the cases were dismissed, the legal effect of that was these regulations are unchallenged. There's nothing challenging them. There's no court decision saying they're illegal. There's nothing saying they're gaming, they're gambling, they're amusement, whatever. So when I looked at it and I was asked, "What do you think, Sandra?" I said, to me, just like I told all of you, I think that they are legal. So they issued the licenses. Then, only then, afterwards, did the AG's office issue the memorandum you're talking about, telling them to, hey, stop, you know, we didn't mean that. So the letter did not come before they issued the license. The letter came after they issued the
Did you know that,
Yes.
that the Attorney General is the
Vice
legal
Speaker, please.
counsel for Department of Revenue Tax?
I know, yes, and they do have an assistant attorney general assigned to Reventax. And I believe they did
But
check
you
with him.
you are not. You are the governor's legal counsel, is that
That's right.
correct?
I was just simply a second opinion.
And is there not an ethical rule, a code of professional responsibility that says that if you know that they have their own counsel, that you shouldn't be giving him counsel?
Well, the Department of Reventax is an executive line agency under the control of the governor's office.
The Attorney General, who is their attorney?
Their attorney is, they do have an assistant attorney general assigned to them.
And you know that there's one that's assigned to them?
No.
And do you have a professional responsibility not to be talking to clients who have their own attorney?
I am aware of that responsibility, yes, sir.
All right, then I guess we'll see what the discipline board has to say about that.
Senator San Nicolas, you still have the floor.
Thank you, Madam Speaker. So again, I would like to reiterate, we're not a court. We're not going to be able to make a determination here as to the legality or illegality of the operation. The real question is, can we tax something that has been licensed by this government? Now, the only concern that I feel needs to be addressed that was raised was whether or not the levying of those taxes is going to legitimize the operation. And so what I would like to ask is that we include some language in here somehow that would say that these taxes as assessed do not affirm the legality of the operation, or do not speak further to the legality of the operation. So I would like our respective minority and legislative legal counsels to advise us as to whether or not we can include a statement to that effect in this bill so that we can move forward, because I don't see us moving forward here. We're not going to be able to render a judgment as to whether or not this is illegal.
Senator Limchiaco, you have a proposed motion on the floor. I do have several other speakers who want to speak. I have Senator Mike Limchiaco, Senator Aileen Yamashita, and Senator Tom Ada now. So what I'll go ahead and do is, if you can, he's making a proposed motion. No, Senator Limchiaco wants to speak, I guess. So I'll go ahead and have you confer with legal counsels. I will go ahead and entertain Senator Yamashita. Senator Limchiaco has been patiently waiting, so so do you have a motion for an do you have a inquiry? Or do you want to add to his
Okay.
point of
I guess
information, point of inquiry?
Point of inquiry.
Thank you. Please proceed.
Thank you, Madam Speaker. I need to understand the rules of engagement here, and so please help me remember. But see, my reaction or my thought to the previous speaker and what he's saying and the language that is wanted, you know, in reading 11 GCA, in reading what and how the licenses have been rendered, they were rendered in a right and correct way. So I don't know why we're suggesting that they're illegal. And so that's, you know, and I'm listening, and you know, and I know how to read. So, you know, that's why I'm curious as to what is going on here. And so again, you can remind me of the rules of engagement for this committee of the whole. But I'm just, when we, you know, we're going to proffer the, I certainly appreciate what the previous speaker is saying, that we do want to move on. I appreciate that.
Yes.
But I'm also hearing, when I'm reading 11 GCA, and I'm reading that the poker machines were repealed, and I'm reading that there were amusement devices that are still there, and I'm listening to how the court processes were determined, and that before 2001, those machines were deemed fine, and they were licensed with rules that were properly promulgated, and we moved on, and then more conversation occurred, and so then from here on out, that's not going to be renewed, but those sets of machines that were licensed are fine. The amusement devices, the gaming machines. So, Madam Speaker, if I'm out of order, I am out of order, but I would like to know what the rules of engagement are.
Thank you, Senator Yamashita. I will say that Senator San Nicolas has a proposed motion that he may proffer. I asked him to go ahead and confer with legal counsel. So, because of time, I'm going to go ahead, and we do still have this panel up here. I had Senator Lim Chiaco, Senator Ada, and then you, if you wanted to say anything, to ask or inquire any questions or comments to the panel members here. We'll go ahead and make them speak or answer, and if we're done with that, we will get back to the motion. Until then, I'll go ahead and address the floor now, since Mr. San Nicolas is going to give up the mic to Senator Lim Chiaco, if that's fair enough with you. Senator Lim Chiaco, you're recognized.
Thank you, Madam Chair. Senator Cunliffe and Attorney Miller, could you speak to the severability clause in the law that you referred to, the Public Law 2652, and its applicability to the promulgation of the use of 2652 to promulgate the rules and regulations?
Thank you, Senator. As with almost every law that's passed, severability laws are put in so that you can retain sections of the law which are not challenged in court. And so basically what the severability clause says is if somebody challenges any part of this act and it's found to be improper and invalid, then the other sections still are valid. And it's normal language that it come with severability, but no one has challenged the legislature's recommendation and direction that Rev and Tax promulgate rules and regulations.
In your prior response, you had mentioned the 11 GCA 6402 as applying to the importation of the gambling devices. So would you say that the severability clause here, where it states if any provision of this law or application to any person or circumstance is found to be invalid or contrary to law, that's what you're justifying the promulgation of the rules on, is that it doesn't apply because it's the importation of the gambling device?
No. This severability clause in Section 5 of 2652 is merely addressing this bill and this law. It's not addressing any other sections of the law. In 9 GCA 65.20, it's telling you that you cannot import certain kinds of machines. And if their machines are imported and they are determined to be in violation of that section, then they can be seized by the government. Okay? But my position and my point was that the Attorney General was saying, because these machines are being authorized to be used, they are in violation of 6420. But my point was, in 6410, it defines what gambling is. And then the next is 6410 is gambling. 6420 says gambling machines, gambling devices. However, 6465 says any machines that are licensed pursuant to 11 GCA 22202 are exempted from 6410 as being as the definition of gambling. So if those machines are, in my opinion, are exempted from gambling, then they can't be gambling devices. Because if they're exempted from being gambling, and how can they be gambling devices? And that was my position.
Thank you, Senator Cunliffe. The next question I had is regarding the promulgation of rules and subsequent adoption to the GAR, Attorney Rapadas, AG Rapadas. In regards to the promulgation of rules and subsequent amendment to the GAR, does that typically go through the AG's office for approval?
I'm not sure if we
promulgation-
actually see the, do we actually see the regulations that go through?
Oh,
The
yeah.
Civil Division. We
Oh, the regulations themselves, when they came out in 202? No, they didn't come through. Well, I better make sure I was there in 202.
Are you talking in
I-
general?
I don't
Regarding the promulgation
know.
of the rules and subsequent adoption to the GAR, does it go through the AG's office for approval before it's amended to the GAR?
Yes, they usually send them through our office for approval.
So, so that just begs the question as to how were they ever adopted into the GAR without a AG's legal opinion that was in contention to it?
I don't, well, we don't know. When this first came up, I didn't even know these regulations existed. And I had to hunt and find them because they weren't on the compiler's website. And then we finally found them at the legislature. They have been submitted, and then we asked the archivist, if they were submitted with, a financing statement and with a record of a hearing, and the answer was no. And so we saw those regulations for the first time in a pleading submitted by one of the owners in one of these cases. We never saw those regulations before that. Nobody in the office that I talked to had ever heard of them. But then they were, of course, as was mentioned, placed on the website in January. But the regulations did not come through us. They went directly from Revenue Tax over to the legislature and were received at the very beginning of '02. I believe it's '02, yes.
Okay, my last question was going back to...
Hold on, Senator Limchaco, Senator Conliffe.
If I mention all senators respond to that. Rules and regulations that are adopted by agencies of the government, they prepare the rules and they have to be submitted to the legislature. If the legislature doesn't act on them within a certain period of time, then they become automatically into law, but the legislature can act on them themselves. But they require legislative approval to become law.
Okay, thank you, Senator.
Thank you, Senator Limchaco.
And then the last question is regarding you in your prior testimony, you had mentioned that if we were taxing it, somewhat legitimizes it, and that begs the question as going back to the 27th Guam Legislature, I believe that the fees for these machines were raised from $25 to a higher fee. In your opinion, would that have legitimized these machines at that point in time?
Well, see, the fees come from 22.202, 11 GCA, and that's the thing. These devices are not listed there. Gaming devices are not listed there. There are all kinds of devices listed. Gaming devices is not one of them. And so they're not in there. They're not in that section. And,
Mr. Mesa, isn't that subsection F?
huh?
Isn't it listed as subsection F of 22.202?
Section F. Is that? Oh, you're going to add this as to the gaming device, electronic gaming devices registered on this as always show B and annual license fee.
No, I think
Well,
what was said...
no, yeah, you stated I guess you will add it to
No,
that.
prior
and that
to
will
that, that's the
legitimize.
proposal. No,
that-
that's the proposal. What Senator Limtiaco was asking about was when those were raised, and the subsection is here, subsection F. That's what his question was. Is that because they were raised from, I think, 25 to, I believe, to that amount, whether that legitimized it. Right?
Well,
Is that your question?
That is my question. And this just goes back to the prior testimony that you made, that if you went and tax it, you could, it basically you're legitimizing that activity. And my question was, does that happen back in the 27th Guam Legislature? So would you say if you're of the opinion that since that tax or the increase in fee was issued, that it further legitimized the gaming devices?
No, because those regulations, we believe, of course, never went into effect. And as the senator just stated, they were not listed in 22-202. This is the first time they would be listed as devices that can be licensed by DRT.
But
This
what-
adds them to the list.
But what fee were they charged? Weren't they charged $500 per license? Madam, just as a,
Information, Senator Respicio,
just as
I mean,
a,
inquiry.
just so we don't veer too far off, I appreciate Senator Lemtiaco's questioning, but I want to ask the Attorney General, if you said those things didn't go into effect, when the licenses were issued, how much was charged per license?
Well, Reverend Tax will have to ask you that. I assume, well, I don't know what they charged.
Well, let's get the information from Reverend Tax. How much did you charge per license?
I believe it was a smaller amount, but it went up to $500. I have to go back to the code and check what was it used to be, but now it's currently at $500.
Yeah. Okay, so that essentially went into effect. Thank you. Thank you, Senator Lemtiaco.
Madam Chair, I do
Chaco.
not have any further questions. Thank you.
Thank you. Senator Tom Atta, Senator Tom Atta, you're recognized for questioning the panel.
Thank you, Madam Chair. I just wanted to address the one of the earlier speakers had suggested and had asked legal counsel to assist in formulating some language that would allow us to identify this gaming machines as a funding source, but without legitimizing it. And it's kind of like saying, basically, can we come up with language that says maybe? It is not this, it is not that, maybe. And the concern that I have is that really the end objective of Bill 20 is to identify a funding source so that Guam Memorial Hospital can then go to the bank and borrow $18 million. But the bank is not going to loan $18 million on a funding source that is kind of wishy-washy. So I guess my take then, in just listening to all the discussion, is that when we rise out of this committee, we're going to have to call this animal one thing or the other. And if we don't do that, we basically would have taken the wind out of this bill, and we might as well shelve it because it is be of no consequence. The Guam Memorial Hospital will not be able to go to the bank to borrow on it to meet the debt service that it needs on a loan to take care of its debt. So, I raise that because I really don't want to spend the time trying to craft this really nice legalistic language, but it's not going to achieve the end effect that we want. Thank you.
Thank you, Senator Atta. Are there anyone else wishing to speak? If not, Speaker Pangilinan, you're recognized.
Thank you very much. I guess the one thing I rise to is, if we don't need to, if we're so confident that we're not doing anything, that everything can be licensed under the law, then why are we amending the law? If we are so confident that we don't need to do anything, that all these licenses are legal, then why are we amending the GAR to, what's the purpose? What's the purpose of Section 6, and what's the purpose of the other section that would, put the names of these machines in? Because I think that that's really what the issue is. I think that if I look at this, there is question. The AG is saying that if that he is moving forward based upon the existing language of all the existing laws, including the GAR, that these machines are illegal. And without these amendments, that they would continue to be illegal, and therefore he would have a duty under the laws of Guam to move forward on the delicensing process of these machines. Is that correct, Attorney General?
Yes, if we were to hear from the director that they were going to continue licensing, we would move quickly against that.
Right. And so the effect of doing this is to place further cloud, actually, on whether or not these machines could be licensed, because it doesn't really make them very, very clear, because what we're amending is already unclear in opinions from different sides. You know, one side saying, no, it's very clear in our reading, the other side is saying not. But we have the Chief Legal Officer of the Government of Guam saying that his duty would be to challenge those issuance if these were not amended. And so the question really is on this: do we want to act on a bill that would basically allow these machines to exist as and they are, as defined by law, gambling machines? So if the issue is that, well, they're already legal because they're already licensed, then what's the purpose of all the other amendments? Just say, we'll push you a 4% tax on all legal gambling machines and leave it at that. Everything else reference to GAR and everything else, just delete. And then let's figure out what these legal gambling machines are. But no, we are actually putting in all of those machines that we want to put into there and say, don't challenge these. But still, because we're doing it to the GAR instead of to the statute, there's still a question that, are those GARs duly enacted? And if they're not, then can you amend non-duly enacted GAR? I don't know. Again, that's the issue. So if we really want to do these machines, then just amend the proper statute instead of what is causing all this discussion, and bring some final clarity to the issue. Do you want gambling machines on Guam in the form of match play, symbolic, and liberty? And maybe Uncle Sam, but he just came a little too late or something, I don't know. But that's the question for me. And again, I go back to the Attorney General. Even with the way that this is written, I would still think that the Attorney General's opinion would be to continue to try and de-license these machines under these amendments, because they still do not provide clarity. Is that correct?
That's correct. I don't want this body to believe or think that we're against funding the hospital. I mean, we all have sincere efforts. We want sincere efforts to make sure that our hospital is up and running and solvent. But we need proper and legal ways to assist them. And our belief it is not. And unfortunately, if we were to go forward, this body were to go forward, and we believe that lawsuits were involved, we may have to jump in a lawsuit, which may stymie the actual purpose of the good senator's bill. I mean, I don't want to do that. But if the law is violated, we will be there.
So,
Senator,
Attorney General,
one moment, please. I'll go ahead and yield to Senator Cunliffe. And then
Senator Pangilinan, I just
Rogers.
wanted to make sure. I didn't see anything in this bill that amended the GARs. They amend statutes and refer to the GAR, but I didn't see any amendments to the GAR itself.
Senator Rodriguez.
Madam Chair, thank you for that, Senator. That's what I was going to point out, is that we are amending the statute, but also for General Pottas, and thank you for saying that you don't want this to stymie what the whole intention is, which is for the hospital. So, and I think that's why we're here, is that, so what now can ensure that these devices, which are already licensed today and which we heard from the department, are going to continue until otherwise they see a court order or something. What could we do now to make sure that when we do attempt to pass this bill, that the banks will be able to look at it and say, just like Senator Ada has said, it's not a maybe.
Well-
And also, just to clarify, the reason why we include these, because these are the only ones of issue. These are the only ones that weren't licensed for 5 years and were caught up in a legal battle, but now are not. So just want to make that clarification that that's why these are the devices we specifically note in this bill.
I don't want the hospital. I don't want the hospital to start relying on a funding source that may one day disappear. I don't want to do that. I mean, you mentioned it yourself, unless and until a court stops it. I mean, laws shouldn't be enacted with that in mind. I mean, the laws should be, or bills as they're, I mean, I don't want to project myself in this body's role, but I would suspect that you wouldn't want something challenged immediately, and that may happen. I'm not promising it, I'm just saying it may happen.
So, sir, I'm asking you as the Attorney General, what language do we need to, what is your suggestion in order to ensure that that doesn't happen?
Well, we're going to have to go through this again with a fine-tooth comb, because again, there are some provisions there that we think weren't enacted properly as far as the regulations are concerned. I can't promise you I can't give you something right now. Again, it's going to require a little bit of research on our side, a little bit of our office working together, but I can't give you something right now, and you're going to hold me to it at this point. I want to make sure that what we give you is legal and proper again.
Okay,
That's the
so
main
all
thing.
you're saying here now is that the way it's written here, you think that it's still not clear what the intent is.
This law?
Yes, no, this Bill 20.
proposal? Well, I know it's clear. It's clear that you want to fund the hospital. But
No, but the funding source. I mean,
funding
yeah.
source for us, it's clear that it's not legal. It's clear to us.
It's clear the way it's written here that it's not doing what we've heard. It's not legitimizing.
Point of inquiry, Madam Speaker.
State your point of inquiry, Senator Nicholas.
To the Attorney General, in reference to the line of questioning by Senator Rodriguez, I did some quick research, and I know that there's case law out there that clarifies that just because taxes are assessed doesn't mean that it legitimizes the operation. And the example I found was that, let's say I do an illegal activity, I sell drugs, and I claim the income from those drugs on my taxes, my income taxes. That doesn't legitimize the selling of illegal drugs.
No, I agree.
Yeah, so if we tax these entities, it doesn't legitimize that those entities are legal, because income tax is assessed on income, and if I'm claiming income on illegal activity, it doesn't make the activity legal. And so if we're claiming a tax on an activity that's illegal, that tax doesn't legalize the activity any more than paying my income taxes would legalize the sale of illicit drugs. And I think it's important to clarify, because once that's clear, then we can move forward and vote whether or not we want to pass this bill, because what this bill does is it taxes those operations, but it doesn't state that those operations are in fact legal. It just assesses the tax on them. The same way that we're assessing tax on income, and if you claim income on illegal activity, it doesn't legalize that activity.
Well, the first comment I have is referring to what Mr. Cunliffe referred to. The exception in the criminal code is to these devices that are listed in 22.202. So that would take that out of the criminal code. So that would change that. And I think by listing these as ones that can be licensed, I think a court may well say that what you've done is added a category, which is what you're doing in 22.202, and now it's accepted from the criminal code under the section that Mr. Cunliffe read a little while ago. So I can't see how you can say it's taxed and licensed. You can tax and license it but you can't do it.
Vice Speaker, do you have a point of information?
Just to the Attorney General, is there a difference between income tax and business privilege tax? I know we like to use the euphemism gross receipts tax, but in actual fact, it is BPT. It's a tax for the privilege of being able to do business on Guam.
The difference
And there
between-
would be a difference between that and the example that was used by the retiring speaker about an income tax where you're admitting income regardless of where it's from.
Right.
But this one, you're actually taxing something with a 4%, which is business privilege tax.
Oh, yes, right. There is a difference, yes.
Oh, yeah, I mean, I totally agree. That's when you're taxing income, the income is general, everything. You do something illegal, that's tax. But here, we're pointing our finger at these things and say you can license them and we're going to tax them. And I think any court that looked at that would say, wait a minute, you're declaring them illegal when they've listed them as being able to be licensed by rev and tax?
But for years, these licenses have been paying GRT, have been paying BPT.
They're paying them currently. So does them paying it currently mean that they are legitimate? Then what are we even talking about here? Yeah. But again,
I apologize. If I may, ladies and gentlemen, there's some sidebar here. If you have any comments or a point of information to share, can you please share it with the chair and share it with the body? Senator Mike Nicholas, you had the floor. Your last statement was, if you can repeat it again, and if there was any interjection from Speaker Pangilinan, I would entertain that next. Please.
I just want to clarify that this bill is not going to be doing anything that isn't already being done. We're earmarking the money for a specific purpose, but we're not saying that this business is going to now be legitimate because it's paying business privilege tax. It already is paying business privilege tax. The question of whether or not the operation is legal is a matter for the courts to decide. We are not a court. We are not following rules of evidence. We are not following any kind of proceedings here. We're not calling any witnesses. And so whether or not the operation is legal, I think needs to be left to the courts. But the bottom line is that these companies are already licensed and they're already paying BPT. And whether or not we're going to be earmarking it for a specific purpose or increasing it or decreasing it isn't going to take away those fundamental facts that it's already paying and it's already licensed. Now, whether or not I'm going to vote in favor of Bill 20 is another matter entirely, but strictly speaking, I think that we need to move on and get to the actual bill itself and leave the determination of whether or not the activity is legal or illegal for the courts. Madam Speaker.
Thank you, Senator Nicholas. If there's no one else, Vice Speaker?
Then if we are discussing the bill,
No, what we would do is, if everybody had a chance to speak, I would yield back to Senator Rodriguez because he asked to come back to him in case he had any more inquiries or comments to the panel. And what we would do was recess, excuse the body, then come back.
no, if we rise, are we going back,
Yeah, we
reporting the
would
bill
be-
back as passed?
We would go back to second reading. If we go back, we would go back, I would address the majority leader to
No,
go
when-
back.
yeah.
We're in second reading.
No, you're correct.
We're in-
You're correct, Madam Chair. So, but what the Vice Speaker is asking is, when we rise, we have to be very clear that when we get to the second reading file, that we have additional opportunity to discuss substitute Bill 20 in the second reading file.
Yes.
Because usually when we rise, we have a recommendation. Since we resolve in the committee of the whole to address whether or not this current activity is legal or illegal, it's possible that when we rise, we can provide the findings that from the committee of the whole that this activity is either legal or illegal, and that would be the findings and recommendation of the committee of the whole. But that we would make sure that we would still be allowed to discuss this bill in second reading file. And
Definitely.
and it automatically does not go to the third reading file.
That's right, and I would address you, Majority Leader, to that respect. So with that being said,
no. Then
Speaker-
I've got a question. I just then would, what is the effect of the language in this bill with regards to the legality of these machines? The language that is in here, which amends the statutes, what is the effect of those amendments? Would it clarify the legality or illegality? Would it make them legal? Would it still convolute the issue? What is the effect of the language that is in this bill and the statutes that are being amended?
I think the effect is to add another category, electronic gaming devices, and not only that, but specific ones, so now you only have specific owners, to the category where you can tax them. And I mean, we would argue that it refers to regulations that are not legal regulations, but it's been pointed out here, I don't know that I accept what's been pointed out, that they're just referring to those. They're not taking any action on those. Now, if that argument were to prevail, I think what would happen is, I mean, I'm not saying I'd argue for that, but I'm just saying if that argument would prevail, we would be adding certain specified gaming devices, not all the gaming devices as in the original regulations, that refers to all gaming devices. You'd be adding those to what can be licensed and taxed by the Department of Revenue and Taxation. That's what would happen.
Vice Speaker Cruz, do you have a point of information?
Yes, but if it's the position of the governor's legal counsel and counsel for the petitioner that these machines are already provided for in GAR and everything, then we can strike this section as being superfluous. If it's their position, and that's the advice that she gave the Attorney General's client, then we can strike this because it's not necessary.
Would you like to comment?
But then if we do that, Madam Chair, it'll speak to Senator Ada's question that will create more ambiguity and lack of clarity as to whether or not the bank would actually move forward on a line of credit for the hospital.
Would you like a comment from Attorney Miller? Attorney Miller.
Thank you. Two things. Are we, just for my clarification, are we talking about Section 7 with respect to the amendment of 22-202? It's not 22-202, sir?
In Bill 20 that was sent out, it's Section 6. Since you've already given the Department of Revenue and Taxation your legal advice that they can issue licenses because the code and the GAR are clear, then this section is unnecessary.
Two things. One, with respect to my legal advice, the Organic Act says that the governor of Guam is the tax commissioner. So I am entitled to give advice as the governor's legal counsel because the governor is the tax commissioner. So if the Organic Act tax commissioner...
Income tax.
Income, it says tax commissioner.
Income tax. The Organic Act addresses income tax.
Vice Speaker, if I may, if I just have Attorney Miller, please go ahead and finish your presentation.
Secondly, on this as being superfluous, I think it says it's assessing a fee. It's not just clarifying, legitimizing. I mean, the basis for this is to assess the annual license fee. So if you strike it, you may want to think about putting the fee someplace else.
there's already a $500 fee that was spoken to by these other two speakers today.
Yeah, 500. This one makes it 525.
I understand, but I'm just
So it's
saying, there is an amount already.
A follow-up answer, Attorney General?
Actually, it's a follow-up to the Vice Speaker's question. A possible legal effect is that those machines not listed in here, we may end up going after. The owners of other machines we may go after as misdemeanors. So some people are scot-free and others aren't. Again, I don't necessarily agree with that position. And I don't necessarily take the position that it legitimizes these Liberty machines, but assuming it does, you got other owners and machines that may have their machines confiscated because they're not listed.
Senator Morrison, do you have a question?
Thank you, Speaker. I just want some clarification. I from the AG's office I know there was a referendum on casinos gaming, but my understanding of casino is a facility that houses gaming devices, or the industry that deals with casinos is the gaming industry. So I'm wondering, is casinos illegal on Guam?
Yeah, there's a list of things that are legal, and things that.
Yes, that's correct.
Oh, well, I suppose if it's at a carnival, possibly, but I don't think it's casino-type gambling that's legal. So right now, the general answer to your question is casinos are not legal on Guam.
Okay, so my follow-up to that would be, since it's the industry the gaming industry that deals with this facility or the casino, if we, so to speak, legitimize these gaming devices, are we, so to speak, creating a casino?
I haven't really thought about that, Senator. That's beyond my ken right now. I'm focused on the funding issue. And
So casinos are illegal?
sorry?
Casinos in Guam are illegal?
Yes, right now.
Okay, thank you.
Thank you. Speaker Pangilinan?
Again, I go back to the effect of this bill and the language in this bill and this reference to GAR. I keep trying to go back and on page 6 of the bill, and again, so that we came in here to get the Attorney General's legal position on the bill as written. So the question then is, what is the effect of in page 6 when it says licensing fees, GRT, and income tax collected from companies involved in gaming as provided by 3GCR, etc. This includes those electronic devices referred to in 7114A5 and licensed per 11 GCA 22 Article 2. These devices shall be known as Liberty, Symbolic, and Match Play electronic gaming devices, and only those registered with the Department of Revenue and Taxation prior to August 1, 2001, pursuant through, again, we go back to the GAR, 3 GAR 7114A5. And then you have the second provision that references the GAR, once again, notwithstanding any other provision of law, the collection of a special 4% assessment fee on income on all gaming devices authorized to be licensed pursuant to 11 GCA 2202F and 3 GAR 7114A5 to be known as a GMA trust fund. And then it says that the Department of Revenue and Taxation hereafter shall collect such fees, transmit them to the Treasurer, and it says develop the necessary forms and instructions for the licensing of persons and companies set forth in 3 GCA GAR 701, 97102, and so forth. Aren't those already in place? And why do we need new ones based upon this statute? If you're saying that they're all there, you're all authorized to do everything without the need for any additional law, But now we're saying, no, you have to go back and develop new forms for licensing pursuant to what we are referencing in these statutes, and then to go to Section 7, and then there you say in Section 7 of the bill, Section 7, or I guess it's Section 6 now, would be Title 21, Guam Code Annotated, is hereby amended to read, electronic gaming devices authorized, again we go back to the GAR, registered and licensed by the Department of Revenue and Taxation as of August shall be assessed an annual licensing fee of the 500 commencing, etc. And then you delete all the other stuff of each video type, symbolic amusement machine, or any other amusement machine that is not listed in the Section 1 shall be licensed at 500. Why do we need to reference all these if we're saying under the current statutes you're all free to move forward and license these machines?
Point of
So,
information.
and what would be the effect of putting these laws in the bill?
Senator Rodriguez, go ahead and state your point of information, please.
Thank you, Madam Chair. Madam Chair, one of the questions is why do we have to develop new forms if all these things are already there, and why do we have to reference them? It's simple. This new 4% assessment fee of a GMA trust fund fee is currently not being assessed. So any forms there do not have this. And it's also simple, the fact that now we're saying, because if these machines, and which they are, these machines now are paying their GRT, they're getting assessed their income tax and licensing fees, all we're saying now and making it very clear is that we want now to have a separate form. We want now to have a separate form so that instead of these revenues, which is the practice now that it goes into the general fund, is specifically going to go into this fund, the GMHA Healthcare Trust Fund. And so that, that's why we're trying to make it very clear that that is what we're doing.
Thank you.
John, does every business activity that is dedicated to a special fund in the form for that business activity indicate where the fund is going to be deposited?
If the law specifies that it should go to a special fund, I think that's why they're doing this, because now they're trying to get all these GRT that are coming from this particular gaming devices to go into the health fund.
No, but I'm asking you, is that the normal practice at RevTax?
If a law is passed, yes. And normally it's not only RevTax, it also has to be controlled by the Department of Administration, because it has to go into specific, I think I mentioned also DOA here, that they have to ensure that these funds are placed in a fund.
So when I apply for my car license, it specifically says that the fund in part of the application and the form says that it shall go to the abandoned vehicle fund or something?
Yes, it goes into the Territorial Highway Fund. Yes.
Okay. All right.
Any comments? Okay. Senator Rodriguez, I did say I'd yield back to you if there was any more questions or if not.
The Attorney General had replied to the question here in terms of what the effect of those sections I read and why are they necessary. What is the effect of that on the legality of these machines? How do they clarify or not clarify the legality of these machines, if that's the intention?
Well, I'll tell you what, from my point of view, what the difference is right now, I think it's very clear that gaming devices are not legal on Guam. And so what we're doing here is we're actually allowing them to license these devices. Now, I would argue because of the references to GAR that, of course, that those references make this law not proper, because it's referring to stuff that's in regulations that haven't been adopted. But when you go to court and you see the legislature has actually added this new category, that will be a strong consideration for the court. I mean, that's the only way I can really put it. I can't say what actually will be done, because I will probably be arguing against this, because I don't think they're legitimate, but I'm sure the court will look at the fact that the legislature has added these. And I might point out something else I think it's being missed. We have liberty, symbolic, and match play. Those are not the only devices that were licensed in 2001. I know that for a fact. I know that there's one called Uncle Sam. And also, when you refer to the regulations about these devices, the regulations don't have specifically named devices. They just mention,
Mr. Mason, just for the record, just for clarification, I'm going to ask the Director of Revenue and Tax, please, just based on that. Director, can you please state what licenses were given back prior to 2001 that they were renewed and what they are? Because now I'm hearing Uncle Sam again, but this is not what is noted. What are they?
Like I said, there's only three machines that were registered on or before August 1st. And those are the Liberty, the Symbolic, and the Match Play. Those are the only three that were registered on or before August 1st, 2001.
Thank you. Mr. Mason.
Okay, well, I know that when we there's been a claim that Uncle Sam was also in there, and they were the one of the ones listed that was recently licensed. But I'm not disputing that before 2001.
Mr. Mason, there was also a statement said by Mr. Camacho, I'll have him verify it again, regarding that machine.
There was one that was overlooked by my department, and we are taking action to revoke that particular license.
Okay.
Thank you.
I just
Madam Chair, can I just ask, the Attorney General keeps referencing to these rules and regs that were improperly promulgated. I think now he's questioning the authority of the legislature pursuant to the AAA process. Now, who determines whether or not that rules and regs is effective or ineffective based on the process in which it was promulgated? Doesn't the courts do that? Can the Attorney General, have you written any, let's start off with the legal opinion. Do you have any legal opinion that says that those rules were improperly promulgated because it didn't have some EIS and maybe some other elements of a requirement of another law that sets out on for the AAA process?
Just to be clear, we do have, just to be clear, when the law tries to amend this regulation, what we're saying is this regulation, this GAR, was improperly enacted anyway. So for a law to reference an improperly enacted regulation, we believe is...
But you keep saying that, but the law that required Rev and Tax to do the AAA process for the Gaming Commission and to regulate these kinds of activities, there was a notwithstanding provision. So that notwithstanding provision, and we're very careful, and when Senator Cunliffe was a member of this legislature, I think he was one of the first few ones that raised, and Senator Klitsky also said stop using that notwithstanding any of the provision of law, because basically whatever happened up until that point statutorily, it's waived, and that's what Attorney Miller said as well. So if you're saying that the 2652 that told Rev and Tax to do their rules and regs is conflicting with the other law that doesn't allow for this gaming activity, that 2652 had a notwithstanding provision. And also, isn't it true that in the rules of statutory construction, when there's a conflict in the statute, the latter in time prevails? And so while you keep saying that this law was improperly promulgated because those rules and regs conflict with a prior law, who is going to make that determination? We just, as Senator Snickla said, we just keep running in place here, not getting anywhere, when you keep making some arguments and then later on your arguments conflict your prior arguments. First, let's establish if it's true that in 2652 that told Rev and Tax to go and promulgate these rules and regs, there was a notwithstanding provision.
I would never presume to tell the legislature what it can do and can't do. I want to make that clear. I'm just...
Well, you also, your argument about these rules being in effect, not effect, would the argument that these rules should not be in effect is based on the fact that it, number one, conflicts with prior statutes, number two, that it was improperly promulgated because it didn't have all the elements of what was required under the AAA process. But isn't it true that whatever the action of the legislature in the end is the legislature's final disposition, whether there was a public hearing, whether there was a fiscal note, whether there was an environmental impact statement, an economic impact statement. I mean, on the whole issue of LeJohn and the integrated solid waste management plan, Mr. Mason, you were intimately involved in that argument. And when we were arguing that those rules and regs that would have triggered, which it has, the going forward with the LeJohn landfill, and how we've said that those rules were improperly promulgated because it didn't have a economic impact statement, an environmental impact statement, I believe. And the Attorney General's position, which you were right center of that argument, was that it didn't matter, it's too late. The legislature didn't act within 90 days, the 90 days are up, so that rule and regulation is the administrative rule and regulation, and so we just have to keep moving forward.
Well, I can't speak to that because I haven't looked into it. I'm not aware of it. I know that the AAL, in order to adopt regulations, has certain requirements. And one of them is that you hold a public hearing, and then you submit the record of the public hearing and an economic impact statement. That's what I'm saying. That's in the AAL. And when we got a declaration from this body, the archivist, I guess it would be, they said those were not submitted. And I'm not saying that the legislature can't refer to these regulations and adopt them into law. Certainly they can. I mean,
but what happens at that point is that legislature should have rejected those rules and regs based on those deficiencies.
Well,
but it wasn't rejected. It wasn't acted on, so they were promulgated.
But I believe the AAL, for them to be properly promulgated, requires those things.
Senator Respicio, I'm going to go ahead and make a decision based on what has happened in the 27th Guam Legislature and what has been promulgated already and has gone through the section. And unless somebody wants to dispute that, there's, again, assumption and...
Can I ask?
Yes,
something?
you can ask a follow-up question, Senator.
I'm looking at the gaming chapter 7, and the notes referring to all this issue. And it says, the original publication, rulemaking authority for the formulation of gaming control laws and regulations by the Department of Revenue and Taxation is found in Public Law 2654, Section 4, October 17, 2001, which states, notwithstanding any other provision of law, the Cockpit License Board, together with the Department of Revenue and Taxation, is hereby authorized to promulgate necessary rules and regulations to create a comprehensive regulatory scheme to regulate all gaming activities on Guam, provided that the rules and regulations shall restrict gambling activities to those authorized and licensed on Guam as of October 1st, 2001. Pursuant to this authority, the Department of Revenue and Taxation filed gaming control regulations with the Legislative Secretary on January 3rd, 2003, consisting of rules and regulations now found in Article 1 to 5 herein, 5 GCA 91, Guam Administrative Adjudication Law. The submission from the Department of Revenue and Taxation stated the following. Upon codification of these regulations, Chapter 5 of Title 11 of Guam Code Annotated will be repealed and reenacted to be replaced by these regulations. And Chapter 39 of Title 22 Guam Code Annotated is hereby repealed in its entirety and reenacted under Chapter 5 of Title 11 Guam Code Annotated. Then it goes to say, however, Section 4 of Public Law 2652 did not authorize the Department of Revenue and Taxation to repeal and reenact existing Guam law. Section 4 of Public Law 2652 authorized the Department of Revenue and Taxation only to promulgate necessary rules and regulations to create a comprehensive regulatory scheme to regulate all gaming on Guam. Public Law 2654, Section 4, October. The gaming control regulations are not codified in the Guam Code Annotated, but replaced in this chapter. what does that mean? Because we're now going back to that authority. So what does this note mean with regards to what is being discussed in this bill referencing the GAR, Chapter 5, Title 11, and all that?
Well, I believe it means that the department is not authorized to repeal and reenact duly enacted law just because these regulations were submitted to the legislature. Because these were prepared by Rev and Tax, submitted by Rev and Tax. Rev and Tax has no authority to change duly enacted law. And even if those regulations go into effect, if they conflict with duly enacted law, they cannot be enforced. That's a maxim of law that's been around a long time. And I tell you, I'll add the third argument I have on these regulations is this is a cockfighting law. And when the legislature, and this is according to my legal research, I'm not telling the legislature what to do. When the legislature authorizes rules and regulations, in that law that authorizes those rules and regulations, they have to set policies and parameters for the agency to act under. You cannot just take a law that has nothing to do with overall gambling on Guam and delegate that to the Department of Rev and Tax. And that's what one of the reasons this note is in there, that they can basically now have duly enacted law prepared not by the legislature, without any guidance by the legislature, but they prepare, and that replaces duly enacted law. And I believe that's part of what this note means.
Okay, are there any other questions for the panel? If none, Majority Leader? Are we going to entertain that after the panel is excused? Okay, great. I want to thank you guys for coming down here this afternoon. Thank you. Thank you. Appreciate it. Thank you. Majority Leader?
Thank you very much, Mr. Chairman. Mr. Chairman, having given the privilege and opportunity by the Attorney General himself and Mr. Pat Mason, as well as the Director of Revenue and Taxation and Attorney Miller and Attorney Cunliffe, there being probably no other business before that particular aspect of this bill, I move that we rise from the Committee of the Whole with the recommendation to continue deliberations on the second reading file, and that the Committee of the Whole wishes to thank the panel for their time and their guidance in hopefully bringing us closer to a resolution. And so that's my recommendations and findings, that we rise and we continue on the second reading file. So to make sure that we don't rise, and automatically goes to the third reading file.
Okay. On that motion, is there any objection? Motion carries.
Thank you. And then now, Mr. Speaker, now that we're back in a regular session, on your behalf, I move that to report the findings of the Committee of the Whole, which basically thank the panel for their discussion and their guidance, and that this body will have to further deliberate the substitute bill in the second reading file, which we're at right now. And so, having reported the findings of the Committee of the Whole, and it being 5:25 p.m., I further move that we recess until 9 a.m. on Tuesday morning.
Okay. On that motion, no objection? We're in recess.